Bom dia a todas e todos, bem-vindos, bem-vindas a mais um evento do Grupo Direito e Políticas Públicas, Faculdade de Direito da Universidade de São Paulo. É um prazer tê-los aqui para esta palestra, para esse encontro, no qual nós temos a honra e a satisfação de ter o professor Kevin Davis, da NYU, para uma palestra intitulada The Concept of Uncertainty. Professor Kevin Davis é professor da NYU desde 2004 e antes disso foi professor na Universidade de Toronto, no Canadá. O professor Kevin Davis tem uma graduação em economia, mas também é um jurista. Trabalhou com um juiz da Suprema Corte canadense, o Justice John Sopinka, entre outros trabalhos que fez. Tem um LLM pela Universidade de Columbia, foi professor visitante na Universidade de Southern California, fellow na Universidade de Cambridge, na Inglaterra, visiting lecturer na Universidade of West Indies, em Barbados, e o professor Kevin Davis tem uma agenda de pesquisa e de investigação no campo dos contratos, da regulação das práticas de combate à corrupção no plano internacional, tem uma agenda importante também no campo do direito e desenvolvimento, entre outras coisas. Eu vou pedir licença a vocês para passar para o inglês, para que ele possa nos entender. His last book, recently launched. About two?
No, soon. Which one?
Very soon, okay.
Which one?
The Quiet Power of Indicators.
Oh, no, that's all. Yeah,
Okay,
you're
is
right,
this
that's-
what is? We want to know about the next two.
Okay.
Well, his last published book is called The Quiet Power of Indicators, something related to what he's going to show us today. Professor Kevin Davis, it's a great honor and privilege to have you here today with us at the University of São Paulo. Please be welcome, and thanks again for your kind willingness and acceptation for us, for our invitation. It's wonderful to have you here. We know you and read you not only when it comes to this type of subject, but also, especially in my case, in my courses when we talk about law and development. So it's really fantastic to have you here. I hope that this is the first time that you come here at this type of circumstance, but not the last one. So I hope to establish a rich dialogue and cooperation with you and with NYU too. So without further introductions, I will pass the word to Professor Kevin Davis for his talk, and then we hope to have time for some conversation. And Professor Kevin Davis was kind enough to let us know that he doesn't bother being interrupted while he speaks. So if we have questions during his presentation, we can ask questions, but we can also do that when we finish. Is that okay? Okay, wonderful. Thank you, Kevin.
Thank you very much, Doga. It is a real pleasure to be here. I've never presented anything at USP before, so I'm glad to be here, and I've heard a lot about the institution and about all of you, and that you're the best law school in the country, and anyway, it's a pleasure. So the paper that I'm presenting today actually comes directly out of my research on law and development, right? It is motivated by my interest in trying to figure out the relationship between law on the one hand and economic outcomes on the other hand, right? Sometimes I think the best way to investigate that relationship is by doing in-depth case studies, right? And or collecting qualitative data to try to understand what people were actually thinking when they either enacted a law or decided how to respond to it. But on other occasions, I think it's useful to actually do quantitative research, right? To again understand that relationship between legal outcomes and any economic or social or even political outcomes. And as some of you might know, there have been many efforts recently to try to produce quantitative measures of various characteristics of legal systems. And in the past, I've written about some of those, including in the work on indicators that I've done with some of my colleagues. But actually, I'm just curious, how many of you have heard of things like the World Bank's Doing Business Index? Is this something that, okay. It's, even in smaller countries, people seem to be even more aware of it, because it's this measure that the World Bank has produced of the ease of doing business, but it's actually basically a measure of the quality of the certain aspects of the legal system. So for instance, they ask, how long does it take to set up a business, or how long will it take to resolve a contractual dispute? There are other measures out there, some of them less sophisticated, that look at how strong are property rights, right? What is the likelihood that you'll be expropriated and so forth, or how strong are protections for human rights. And so this is an entire field of study and research and practice, trying to produce these indicators, trying to refine them, and then trying to use them to test or develop theories of law and development, right? Like, do strong property rights contribute to development? Or does it promote economic growth to make it easier to open a business, right? But to do that kind of work, you need the measures. You need to be able to measure the legal system. And so in that vein, I've often been struck by the fact that a lot of these measures are produced by economists, and they focus on topics that they think are important. They focus on aspects of the legal system that seem important in their theories, usually the strength of contracts and property rights. But as a lawyer, I'm not sure that they're actually capturing everything that matters. And this paper is part of an effort on my part to think about what might be missing in the existing inventory of legal indicators. Right? The paper itself actually did not come out of the work on indicators, although it informs it now. It came out of a study that I could talk about if you like, where we were trying to figure out something about property rights in Canada, Aboriginal property rights in Canada. And we ended up thinking, oh, well, the important factor here is legal uncertainty, right? And that's what seems to be explaining why they just can't resolve this particular set of disputes. And that made me realize that, well, two things. First of all, legal uncertainty is important. And I'm sure all of you have been exposed to, been in conversations where people have asserted, well, what we really need is legal uncertainty. Even talking to Brazilian lawyers over the past week or two, there have been innumerable complaints about the level of legal uncertainty in Brazil. I'm in no position to judge, but it's a concern for business people and the lawyers who have to advise them. And if you go back through the theorizing, I mean, it goes right back to, well, at least Max Weber talking about the importance of legal certainty to the development of capitalism. So I think I'm on fairly solid ground in asserting that this is an important thing. This is an important feature of a legal system that we ought to try to capture. The challenge is to figure out, well, first of all, what does the concept mean? And secondly, is there any practical way of measuring the level of legal uncertainty associated with any given legal system at any given point in time? And so that's what this paper is about. It's the conceptual part and then this practical question of how to measure it. But the ultimate goal is to use those measures to do things like say, well, if we create specialized courts, will that increase legal uncertainty or decrease it? I mean, so the ultimate goal is, some future work that I and perhaps all of you could do using these kinds of measures. Okay, so it's a very much a methodological paper. So here's the basic intuition. This, I think, captures most of what's in the paper, actually. After that, it's just math. The idea is that there are actually several different conceptions of legal uncertainty, not just one, and that we need to distinguish them carefully if we're going to make any progress in this area. So the hypothetical illustration that I use is a particular fact pattern, right? I have to specify the fact pattern, and here it's a car accident. Right? So let's assume that it's a civil action where the plaintiff is supposed to be suing the driver who's caused some sort of injury, and we ask various people, who those people are will matter, I think, but just ordinary people, about the probability that the plaintiff will win. And let's say we're focusing on a particular legal outcome, not just winning, but let's say winning $1 million, let's say. So we'll be very specific. And let's assume we've described the fact pattern so we know exactly how fast the driver was going and so forth. And to try to capture the measure of the level of legal uncertainty in the legal system that these people are living in, we would ask, well, what are the odds, or what do you think is the probability that the plaintiff will win now that you know all the facts? Right? Say you ask 10 people, one possibility is that they all say 50%. Right? And that, I think, reflects a considerable amount of legal uncertainty, perhaps the maximum amount of legal uncertainty. It couldn't be more, right? It would be, the outcome would be certain if it was 100%, or it'd be certain if it was 0, right? Either of those outcomes is certain, but 50-50 is the maximum level of uncertainty. Okay? So that's one conception of uncertainty. Right? A different conception, though, is if they all say, well, somewhere between 40 and 60%, where we're not really sure. Now, some economists, especially if you go back a few years, wouldn't be comfortable with this idea because they'd say, well, if you press them, they will always come up with a specific probability, right? But the developing consensus now is that actually in reality, some people do this. They assign ranges of probabilities to outcomes, and no matter what you do, you can't get them to narrow it down to a single probability. So in some cases, I think people will give you a range, right? And that range could be either large or it could be small. Right? Sometimes they'll say between 40 and 60%. Sometimes they'll say between 49 and 51%. And I would assert that if they say 40 to 60, there's more uncertainty than if they say between 49 and 51%. It's a different kind of uncertainty from in the first bullet point, but it's another dimension along which we can measure legal uncertainty. Okay? The size of the range of probabilities that people assign. Okay. The third point, I don't think I'll emphasize very much in today's talk, but I do think that the stakes matter. The amount that the plaintiff is likely to win. So I think they'll say in a system, if the outcome we're talking about is $1 million versus 0, you'll say there's more uncertainty than if the outcome is $10 versus $0, right? And I think that matters. But the real point here is that there's a difference between that the perceived level of uncertainty and the economic significance of uncertainty can vary depending on the dollar amounts that are attached to the legal outcomes, right? The actual impact that the law has on people, right? And so the same legal system, the same judges basically, could generate more uncertainty if the stakes that they're working with are higher. That's another way of putting it. Okay, okay, the fourth point. It's more intuitive than it looks, but on the slide it's hard to explain. The short way to say it is, let's suppose that we're not so much concerned about the outcome of the lawsuit that will arise if the person was driving at, say, 100 kilometers per hour. We're concerned about, and so the particular legal proposition that governs that lawsuit driving at that speed, the plaintiff, the driver who was driving at that speed. Let's say the question is, well, how certain are you about the speed limit? Right? Because let's assume the speed limit will affect the outcome of the lawsuit. So what's the speed limit? Is it certain or not? Right? If the speed limit is certain, if you know that the speed limit is, say, 90 kilometers per hour, then if you're driving less than 90, the driver is sure to win. If you're driving more than 90, the plaintiff is sure to win. It could be, if you're absolutely sure, then there'll be that discontinuity, that sharp break in terms of the probabilities that you assign just below the speed limit and just above the speed limit. But if you don't know exactly where the speed limit is, between 80 and 100 kilometers per hour, what you'll see is that the probability that the plaintiff wins increases gradually between 80 and 100, right? Which is a different idea. So as the facts change, the probabilities that people are assigning will change very gradually under an uncertain legal system, right, where the speed limit is uncertain. But if the speed limit is certain, the probabilities that people assign will change abruptly between one set of facts and another. So that's the basic idea. Okay, so the claim here is that, which I hope is something you'll accept, is that we actually have different dimensions along which we can measure legal uncertainty. Right? So that's the first step in the paper. Another step is to attach some labels to them. These are somewhat arbitrary because these distinctions haven't been drawn very carefully in the literature. So all the terms, all these labels that I've put up here are used in different ways by different authors. For the purposes of my analysis, I had to sort of be consistent through the paper, so I'm going to suggest a set of terms, but I'm not necessarily wedded to these, but just for the sake of clarity through our conversation at least, it was important for me to attach words to these different concepts. And so the first kind, right, the 50-50 versus 0-100, but where everyone agrees, I called unpredictability. The next kind, where you assign broader or narrower ranges of probabilities, I called ignorance. When you attach dollar values to it, then it becomes the kind of uncertainty that lawyers are accustomed to talking about, either risk or, economists are accustomed to talking about, either risk or ambiguity. And then this last point I just called indeterminacy for reasons. Oh, and I just realized I forgot to mention the last type. Right? This one is the easiest to understand. So far I've been saying you ask 10 people and they all give the same answer, whatever the answer is. Of course, what happens if you ask 10 different lawyers or 10 different people and they all give you a different answer? Right? So you've got disagreement. Right? That's yet another kind of uncertainty, where the law generates disagreement. The legal system generates disagreement amongst people who are trying to figure out what sort of outcomes it will generate. Okay, so that's my set of labels. In the paper, I formalize this in this kind of terminology, which is not essential for anything that I actually do in the paper, but there are reasons why you might want to do this if you're conducting other sorts of analyses. So the idea here is, first of all, I have to define a legal system, right? And I'm saying a legal system is just a system that assigns legal outcomes to specific fact patterns. So the outcome of you driving 100 kilometers per hour on this particular street under these weather conditions is you're liable for $1 million. So fact pattern, outcome. And also, since I'm focusing on what people believe about the legal system, the legal system includes, is really a mapping, right, between outcomes on the one hand and people's beliefs about the probability of those outcomes occurring in specific fact patterns, right? So that's the key there. And then the law, like the speed limit for the road, would tell you the outcome for a whole range of fact patterns. Right? It might be very crude. It might say above 100, one outcome, below 100, another set of outcomes. Right? And the system is the whole collection. The really important things here are that it's subjective. What I'm focusing on in this paper is subjective uncertainty. Uncertainty in people's perceptions of the law. It has nothing to do, or it doesn't necessarily have anything to do, with what's actually going on in the legal system, what the outcome of this lawsuit actually will be. The people I'm talking about, these respondents, could be completely wrong, right? If you ask the judge, he may be absolutely certain what the outcome will be, right? Or even 10 judges, they may know, right? But what's important for these purposes are the subjective beliefs of people. Their beliefs, which is what probabilities do they assign in their own minds to a particular outcome occurring. I think it's useful to study objective forms of uncertainty. I have no objection to doing that. And actually, it's going to be interesting to study them because they might, or one would hope, that they would influence the subjective beliefs. So if the judges are actually, in fact, unpredictable, then that might explain why people perceive uncertainty of one sort or another, right? Or if they're inconsistent, let's use that term. If the judges are inconsistent, that might explain why people perceive them to be unpredictable, et cetera, et cetera. Right? But that's not my focus here. The focus is on what's going on in people's heads. Why does that matter? Well, because that's what influences their behavior. Right? When people are deciding whether to invest or whether to settle, right? Or whether they're feeling afraid of the particular outcomes and will want to just leave the country or leave the city. You know, it's their beliefs that are driving that behavior, not necessarily the objective reality. So in the causal chain between what's actually happening in the legal system on the one hand and economic outcomes, right, which are influenced by behavior, the subjective beliefs are the intervening variable, right? The objective is mediated by what's going on in people's heads. Okay, so that's the more formal exposition. To do it yet another way, graphically, if we think about the outcomes here being a range of damage awards, so 0 to $1 million, right? If the law is very predictable, then people will assign a very high probability to one outcome or to a narrow range of outcomes. But if the law is less predictable, the red line, right, they'll assign relatively high probabilities to a fairly broad set of outcomes. Right? That's the basic idea. Okay, so if, let's say the outcome is you'll get $1 million. In this case, in the middle, right, on the blue line, most people, everyone says there's a very high probability you'll get $1 million. Right? Let's say that peak is, I don't know, 50%. Whereas on the red line, maybe 40% of the people think you'll get $1 million, but fairly large. Sorry, most people think I was switching or mixing two conceptions there. If on the red line, everyone says there's maybe a 40% chance you'll get $1 million, but there's also a pretty good chance you could get 250 or 750, etc., etc. So that's the unpredictability. Okay. Ignorance is where they're assigning a broader range of probabilities, right, when they're more ignorant. Disagreement, different axes. The axes have changed here. Right? Here we're looking at the percentage of the population that assigns a given probability. So in the blue line, in this case, a high percentage of the population assigns a probability of, this has to be tied to a particular outcome, assigns the probability of $1 million verdict, right? Whereas in the other, on the red line, a lower percentage assigns the probability. There's more disagreement, right? Okay. And here, this is the indeterminacy. This is the uncertain speed limit example, where now I've got the facts on the bottom axis. So as the speed increases, right, in the blue line, once you hit the speed limit, the probability that you will, say, get $1 million, be hit with $1 million damage award, suddenly jumps, right? That's the blue line, right at the speed limit. Whereas in the other case, where the speed limit is uncertain, the faster you go this way, the faster you go, the higher the probability that you're hit with that award, but it increases relatively gradually. Okay? So that's the same thing in graphical terms. Okay, so why do those distinctions matter? Because the only point in drawing these kinds of conceptual distinctions is if, being a pragmatist, is if they actually if they have some cash value, if they actually make a difference in things we care about. I think they do. I think different types of uncertainty affect different outcomes. So we care about, why do we care about legal uncertainty? Sometimes, let's say in criminal law, you don't like to have uncertain laws because you think that they fail to provide fair notice. It's a concern about what, you might be concerned about what Americans call due process, right? It's some sort of rights-based concern, right? That people will be surprised by the outcome, right? That idea that you'll be surprised by the outcome, the legal outcome that is going to be assigned to your actions, that seems to capture the idea of unpredictability, right? Your best guess is still likely to be wrong. So in the case where the outcome is 50-50, right? Even your best guess, whichever one you pick, there's a 50% chance it's going to be wrong, right? Whereas if it's 90-10, there's a relatively small chance that your best guess will be wrong. Okay, so that's unpredictability in my terms seems to be what we care about when we, or what we want to measure if we care about fair notice. Okay. I'll just mention one of them. The others, in the interest of time, the settlement. Right? how many of you have done economic analysis of law, or taken a course in economic analysis of law? Okay. Just so speaking to a handful of people then, in that literature, there's a very famous paper that tries to explain what makes people settle lawsuits as opposed to proceeding to trial. So why do people settle lawsuits? And the authors of that paper say that the more uncertain the law, the less likely it is that people will settle, and the more likely it is that they will go to trial, right? And it's, but their definition of uncertainty in that paper is not about unpredictability. It's actually about disagreement, right? Because people are likely to settle where they agree on the outcome at trial, on the what will happen if they go to trial, because then they can just say, okay, well, I'm going to be liable for $1 million. You're going to get $1 million. We can save ourselves the cost of litigation by settling. But if they're far apart in their predictions of the outcomes, then the plaintiff might say, well, actually, I'm going to get $1.5 million, and the defendant might say, no, I'm actually going to walk away scot-free. I'm going to take my chances. The amount that the defendant will be willing to offer won't fall within the range of what the plaintiff is willing to accept because of their disagreement about the likely outcome. So that's what goes on in that literature on the determinants of settlement. For me, the key point is that they say that uncertainty is the critical variable, but they mean a different kind of uncertainty from what the fair notice people are talking about. These people, the people talking about the relationship between uncertainty and settlement, are talking about disagreement. Right? And in fact, just to put more of a point on it, in that same literature, uncertainty in the form of unpredictability, the more unpredictable the outcome is, odds are the more likely it is that they're going to settle, because people don't like unpredictability and unpredictable outcomes at trial, so it'll push them towards settlement. So in that context, it's very important to know which kind of uncertainty you're talking about. One kind increases the likelihood of settlement, the other kind diminishes it. Right? So that's why I think it's important to draw these conceptual distinctions. Okay, so that's the first part of the paper. What you could do with it, you can talk about, you could then go and do studies of the relationship between uncertainty as you've measured it and any of these consequences. You could also try to figure out what determines the levels of uncertainty, right? Is it whether or not the judges are randomly assigned to cases? Is it the amount of discretion that the statute gives to the judge, right? Is it just the way the media provides information to the population? Are there asymmetries or inequalities in access to legal information? Whatever, those are potential causes of uncertainty. You could do studies of those too, but you need to be able to measure uncertainty. In this case, uncertainty is the dependent variable, the outcome variable. In the prior set of cases, it's the independent variable. Right? Either way, though, we need measures. So that's what the second part of the paper is about. How, in practice, could we measure the levels of uncertainty, legal uncertainty, associated with any given legal system, right? And that in ways that distinguish at least a couple of these different types, the different forms of uncertainty. Okay, so here's what I've come up with. Have any of you come across the World Justice Project? Okay, because sometimes I meet people who've actually participated in it, either in the sort of consultations they did around designing it, or they've responded to the survey that I'm about to describe. So the World Justice Project is an initiative that's associated with not-for-profit that's based in the United States. And their initial interest was in producing a measure of the quality of the rule of law. So it's an indicator of the quality of the rule of law. So they measure the level of respect for the rule of law in each country, each of over 100 countries, publish the numbers, and then they do that annually, right? And there are various reasons why they might want to do it, including taking the measures to the countries that perform poorly and trying to lobby the governments to change, or encouraging civil society organizations to lobby the governments to reform, right? So that's why they're producing their index. I'm not a big fan of the index itself, because I think it's pretty meaningless. This, what is the rule of law, But what I do like about the project is the underlying data that they collect. The data that they collect in order to produce this index. Because it includes a survey of the populations, a representative sample of the populations in each of the countries that they are trying to evaluate. And the questionnaire for the survey has some questions that I find especially useful, right? Like this one, where they ask the respondent to assume that the government has decided to build a new construction project, a public works project in the neighborhood, right? That requires the demolition of private homes. Okay? And then they ask, well, do you think the government will provide fair compensation? Right? And the next question is, if they don't, will people sue? Right? Moving down a bit, they get to the point of asking, well, if they do sue, how likely is it that they will obtain fair compensation from the courts? Right? On a scale of 1 to 4, from very likely to very unlikely. Okay? So what do I like about this question? Well, I like this question because it gives me the data that I need in order to produce a measure of at least unpredictability and also disagreement. Right? Why is that? Well, because it elicits all the information I need about their beliefs about a legal proposition. It gives them, presents them with a fact pattern. Now this one isn't great, right? Because it's a little ambiguous and subjective. So I'm not defending the particular question, but the form of it I like. Because it presents people with a fact pattern, right? And suggests a legal outcome. So the fact pattern is the demolition without compensation. The legal outcome is fair compensation, and then they are supposed to report the probabilities something close to the probabilities that they assign to that legal outcome, conditional upon that fact pattern. Right? That's what we need to map what I called a legal proposition a few slides ago. Right? Fact pattern, legal outcome, probabilities. Now, 1 to 4 is not a very refined set of probabilities, but it's close enough. Right? So, I can use this to produce at least measures of unpredictability and disagreement. For unpredictability, what I do is I ask, well, what percentage of the people who respond, and it's typically 1,000 or so people in each country, what percentage of the people who respond to this question answer either likely or unlikely? So they're in the middle. They're not certain either way, right? So the percentage who are uncertain, that varies significantly from country to country, as it turns out. So that's a country level measure of the amount of unpredictability. Right? So that's the unpredictability side. And then for disagreement, I just take the standard deviation of the responses. So how much disagreement is there about whether it's 1 to 4, right? Is it a situation where everyone's answering 4, or everyone's answering 2, or is it a situation where they're all over the map? Right? And that's my measure of disagreement. Okay? So I like this. Now, again, I'm not saying this is a perfect question for my purposes, mainly because the fact pattern is not described very precisely. And also it's subjective, as I mentioned before, because the public works project is in your neighborhood. So there's a sense in which everyone's answering a different question, because they're answering a question for their own neighborhood. And fair compensation is not very precisely defined. So, if it were up to me, I would have a better question, but it's a start, right? Of course, you'd also ask them maybe to provide, on a scale from 0 to 100, how likely is it? And you would allow them to present ranges, to report ranges of probabilities or likelihood. So that would be the perfect question from my perspective. But again, as a proof of concept, this works. Okay, so now to make sure that this paper is actually worth writing, I also have to show that these are different things, right? That these are not perfectly correlated, because if all the different forms of uncertainty move together, right? If unpredictability is always associated with disagreement, is always associated with ignorance and indeterminacy, then again, there isn't much point in drawing all these fine distinctions. So what I did was to look at different countries to see whether they move together, right? And, it's actually interesting. They look different, right? So if you look at China first in the top left quadrant, you see that people are pretty sure, sorry, just to give you the scale again, 4 is very unlikely, right? So what are the odds that the government they'll obtain fair compensation in court? In China, most people say it's very unlikely. Okay? So but they're pretty certain about it. Right? So there's not that much disagreement. I don't actually care whether it's 1 or 4, but for my purposes, what's interesting is that there's relatively little disagreement. The answers are clumped together, right? And they're quite certain. There's little unpredictability as well. Okay? Whereas in Uganda, it's somewhat different. Again, there's relatively little disagreement, but there's a lot of unpredictability. They're all saying, something in the middle. Right? Then moving down as we go down from, Jordan. I'm sorry, I was reading from the bottom. Jordan is where it's, there's little disagreement, but it's very unpredictable. In Uganda, so down in the bottom right, it's different again. You're seeing it spread out, what economists might call a mean-preserving spread, right? So that it's, there is more disagreement, but still a fair amount of unpredictability. And then in Kenya, even more disagreement, right? But necessarily, there's less unpredictability because as the disagreement increases, you've got some people at either end of the spectrum. Okay? So we do see differences in these countries. To be quite honest, I'm not sure what to make of these. So the next paper is going to basically mine all this data to try to figure out what's explaining these kinds of differences. But at least it's showing that unpredictability and disagreement don't necessarily move in the same way, right? And so if you look at the map, the scatter plot of all the countries from the survey, you'll see there is this nice relationship down the top, this negative relationship between unpredictability and disagreement for a lot of countries, but China is way down at the bottom. It's a big outlier, as are several Southeast Asian countries, right? So Myanmar, Thailand, Hong Kong, the Philippines, right? Now you could just say, well, they're outliers, we can ignore them, but that's a quarter of the world's population, right? So that doesn't work. So there's something there that we need to explain. So that's how the scatter plot corresponds to what I showed you before, the histograms that I showed before. Okay. Now what's interesting, the other interesting thing is that this is tied to a particular fact pattern, right, and a particular legal outcome. You can do this for other fact patterns and other legal outcomes, though. And the nice thing about the World Justice Project survey is they ask other questions that have the same format. Right? So a different one is basically a constitutional law question, right? So if the president adopts a policy that's clearly against the Constitution, how likely is it that the courts will stop the illegal action, right? So that's the constitutional law question. An administrative law question is also in there. So assume a government officer makes a decision that's clearly illegal and unfair, and people complain. How likely are judges to stop the illegal decision? I think of that as administrative law. For countries in which customary law is an important part of the legal system, there's a question there about, well, what if if you bring this complaint before a chief or some other traditional ruler, what is the so there we've got a different kind of legal outcome now. Not only so same fact pattern as in question 10A, but different legal outcome. The legal outcome here is the decision of the traditional ruler as opposed to the judicial decision. I don't really care what sorts of legal outcomes we investigate. That for me, a legal official could be a police officer, right? And you could look at how unpredictable, how much disagreement is there about how police officers behave, or chiefs, or lower court judges, or the Constitutional Court, whatever. I think this methodology, these measures can be adapted to a range of fact patterns, to a range of legal outcomes, right? One of the reasons, so that was one of the reasons I wanted to show you these other questions. The other is to point out that the nature of legal uncertainty in a country might vary depending on which part of the legal system you're looking at. So which fact patterns, which legal outcomes, right? That plot looks somewhat different from the plot. This is the plot for this last question, for the constitutional law question, right? It looks a bit different from the expropriation question. Right? And then on the administrative law side, there's more consistency across countries. So for me, this emphasizes the significance of really being clear about which part of the legal system you're focusing on when you're measuring. Because at the end of the day, even though I dabble in this sort of quantitative methodology, I sometimes call myself a radical contextualist when it comes to law and development studies. So, and I think this idea of generalizing across an entire legal system about the level of respect for the rule of law in Chile or something, I don't think that way. I do think it matters. It depends on, well, what do you mean by the rule of law? Let's leave that aside. But in which part of the legal system, right? So this preliminary analysis suggests that those distinctions matter as well. Okay, so that's basically it. There are other business law questions, but there are other surveys that you can find that have that structure, sort of. Fact pattern, legal outcome, what is the likelihood? Hopefully people will produce more of them, because I do think this has been overlooked as a feature of the legal system, or as a set of features of legal systems that are worth measuring, and I'm hoping that the more empirically minded among us will take up the suggestion to go about collecting this kind of data and then producing the measures and using them in analyses of either the causes or the consequences of legal uncertainty. That's it.
Thank you so much, Kevin. This was great, very interesting and thought-provoking. We are now opening the floor for questions and clarifications people want to ask for. And if you want to do that in English, great. If you do that in Portuguese, we can translate. So let's start. I have one here, too. Vou pedir para as pessoas virem aqui, por gentileza, para se apresentar, se quiserem se apresentar, mas para fazerem a pergunta aqui no microfone, porque a gente está gravando esse evento para poder depois ouvir o que as pessoas disseram. Por favor. So, Henrique. So we have Henrique, Beatriz, Guilherme. Mais alguém aqui? Primeira rodada e depois a gente faz outras rodadas.
Thank you for your talk, Professor. I just have one very simple question. I know this would be a little hard to measure, but from a conceptual level, could you say that there's one other type of uncertainty that you didn't mention there? Is that maybe people, if you ask them the probability of one kind of outcome, they just say, I have no idea. And I'm asking this because I feel like that's how most people would answer, at least here in Brazil. And maybe if you force them to come up with some probability, it would be artificial. So I know it poses some challenges for measuring, but from a conceptual level, could you say it's a different kind?
Thanks. I think it's a really good question, but I actually think it's easy from a practical perspective and hard at the conceptual level, because economists actually, the people, and not just economists, but people who've thought about what it means when someone says, I don't know, well, they still don't know. They're still struggling with that one. At the practical level, it is actually very easy to measure that, because that survey actually has that as another option. One of the options, which I didn't mention, is don't know. Unfortunately, the version of the data that they provided to me was cleaned, and so they stripped out all the I don't knows. But I think that's actually extremely useful information. We're just not entirely sure what to do with it. So yes, I'm sympathetic to the idea that we should just call it a separate kind of uncertainty. It doesn't vary very much, though. But like, how sure are you that you don't know? Do you really, really don't know, or yeah, that kind of thing. But no, I think that's very important. Beatrice?
Thank you for the talk. It was great. And my question is related, I think, to the distinction between subjective uncertainty and objective. When you say you are trying to measure the perception that people have of the uncertainty, you're meaning regular people, not people with a legal background, right? Because I think that maybe the outcomes would be a little bit different if you're thinking about judges or people who has some kind of legal background who could better understand the circumstances in which the cases are being discussed. Would that somehow change how it will be measured and the outcomes?
Yeah, no, that's also a very important question. I'm sure the answers will change depending on who you ask, so who the respondents are. So who you ask should depend on the purposes for which you're conducting the analysis, right? So let's say it's a question about shutting down expropriating a microenterprise, let's say, where the people who you care about, whose behavior you care about, whose beliefs you care about, are not likely to consult a lawyer. Right? In that case, you'd want to survey people who are representative of that group of people, and not lawyers, right? The micro-entrepreneurs who are not going to. So that's who you'd ask. And if you asked, say, a classroom full of law students, that would be a mistake. But if it's about expropriation of owners of large supermarkets who will consult lawyers, right? So their beliefs are going to be based, and their actions are going to be determined by what their lawyers told them, right? Then the relevant set of respondents should be the lawyers. So I think it really depends whose perceptions you care about. But that's beyond the scope of this paper because it will vary depending on the reason why you're asking the question, right? Does that make sense?
Yeah. Thank you, Professor, for your presentation and the paper. It's very interesting. It's very fascinating. I think it opens a great range of possibilities for further research and topics. And one of the challenges that came to my mind as I was reading, and this relates to the other two questions that were already made, is that you emphasize in the paper that this methodology has to be adapted for different circumstances, actors, or whatever you're trying to measure. And one of the things that caught my attention is that decisions, the idea behind the measuring legal uncertainty, it seems to me the main purpose is also to make relations with behavior, or let's say to so how uncertainty can influence or change a behavior according to the law. And what caught my attention is that behaviors also, it depends, some decisions, some behaviors are made on the spot, but some are processes, as you just mentioned. Sometimes it involves consulting lawyers and so on. And so what I see is a sort of a relation in some circumstances. If we're talking about measuring, for instance, the uncertainty of an outcome that about contracts, there might be a huge process involved in assessing the objective uncertainty. So I'll pay lawyers to research and try to find what is actually my the real outcome, the real probability of a certain outcome, and based on that information I will make my decision. So is there an impact on the methodology? I mean, are surveys, for instance, or these polls, are they capable of also measuring the sort of complex decision-making processes, which are probably very relevant also when we're talking about big behavioral changes in economic consequences and so on of legal uncertainty? So not only this subjective perspective, but is it possible to achieve, is it possible to find out the objective uncertainty, and with that, so is this complex relationship between subjective and objective?
Okay, so there are a few points there. First, I'm not convinced that whatever the lawyer's beliefs are will qualify as objective. Right? That I'm not sure how many lawyers do the kind of statistical analysis that would make me feel that they of outcomes of past cases and so forth that would make me feel like once they've done the analysis, everyone will agree, and there's just no doubt in the sense that it'll qualify as objective. So let me bracket that, or maybe if you'll indulge me, and I'll just say that even the lawyer's beliefs might count as subjective for my purposes. Okay. Right. I didn't think you were wedded to that. So so that's one background point. The second background point was about whether the purpose of this analysis is always to think about influences on behavior. Are we ultimately only concerned about behavior? I don't think that's right. Most of the literature that I'm working with, at least in law and economics, assumes that, right? A lot of it's about deterrence, and so the effects of legal uncertainty on the behavior in the sense of whether or not decisions whether or not to comply with the law. But that's not necessarily the only reason why you would want to study legal uncertainty. You could want to just assess how uncertainty affects people's sense of well-being, right? Do you like just general sense of security? Do you feel unhappy, ill at ease when you're in an uncertain legal environment? In principle, you could be interested in that. I also am somewhat interested in the relationship between legal uncertainty and I can't remember how to put it on the slide, but the ability to store and record legal information, right? Well, actually, to access legal information, because if the legal system is very unpredictable, so thinking about judicial decisions now, if the judicial decisions in a particular area are highly unpredictable, right? It's going to be hard to, you're going to have to require more processing power or more storage capacity to capture or you might need more storage capacity to capture information about the set of outcomes. So you might actually have to, give people, you might have to say, here are the 10 decisions that occurred that have been handed down in the past, because each one of them is different. Whereas if they're all consistent, you could just take one and it'd be representative. So you'll have to record one as opposed to 10. That's the basic intuition. It's a little more complicated than that, because if the 10 are different but they follow a well-recognized distribution, then you might only need one piece of information about them. But at some point it might require there might be more information embodied in an unpredictable set of set of decisions, right? Set of legal outcomes. That's interesting to me as well, because if it's that there's a sense in which the more unpredictable it is, the harder it is for people to just access the information. They'll have to study you'll have to read 10 different cases to be able to get a sense of what's likely to happen, as opposed to just reading one. And that has implications for access to legal information, or if you want to think about it, access to justice, right? So that's somewhat removed from thinking about behavior, right, as well. So that was another sort of background point that you made. But I can be much briefer in answering your main question, which is, are surveys the best way of eliciting information about beliefs that are formed through some sort of process of perhaps deliberation or research? I think the answer has got to be no. You'd probably need something other than a survey administered in the traditional way. I mean, you could actually commission 10 law firms to go out and come up with their beliefs about the likely outcome of a case after they do the research, and so that could be a survey of sorts. But I think your intuition is right, that you do need a different kind of instrument from the one that I've described here. If it's deliberative, so it depends on the conversation. Again, you could do focus groups and then have people report their beliefs, but that's more complicated. So yes, that's right.
Okay.
Hi, my name is Sarah. I am a PhD student in this school, and I have actually two questions. You poses big challenges to the way international institutions take cross-country analysis in legal certainty. And the first question would be if you plan to propose any improvements on the way this kind of data is collected, since you are critical about this as well. And the other question is, well, you said in your speech that you are a big enthusiast of context, and I would like to know how this model could be useful to undertake case studies, like what explain patterns in China or in Venezuela, which are the cases dispersed in the graphics.
So it's not a strong challenge to existing data collection practices. It's more of a suggestion for additional data that people could collect. I've antagonized the World Bank and so forth in other publications. This one is more of a friendly amendment, or even a just suggestion or request even. Okay, you could add this type of question to your survey, or have more questions of this sort in your survey. So that was the first question. In terms of informing case studies, well, yeah, I would, if we go back to the histograms that I showed comparing, say, China and Jordan, I would want to know, I could imagine, okay, so what explains the much higher level of unpredictability in Jordan as opposed to China, right? You could use these measures, pick your area of law and say property law, to inform your case selection, right? That's, I think, because at the end of the day, this is a quantitative tool, right? But you can use it in the same way that you use any other quantitative tool in relation to case studies, which I think is to inform your case selection and then move forward. So you'd look for patterns, you'd look for the outliers in this case. That's one way of of selecting cases, to take an outlier, like say China, and look at a country at the other extreme maybe. So that's what I would think. And then figure out, well, what is it about property rights in China that creates so much certainty as opposed to in the Jordan case. That's my initial thought. Did you have something else in mind though? Right. So, yeah, then you wouldn't necessarily be. So you could use these measures in the comparative sense to inform the case selection, but then I would treat them as you could also treat them as your outcome variable to do a sort of process tracing to figure out, well, what was going through people's minds when they responded in this way. Or what happened in their lives to lead them to respond this way. So yes, you could use it, you could treat it as the outcome, the response there, or the measure that you come up with, as the outcome to be explained in that kind of process tracing study as well.
Hi, Professor Davis. Thank you for your presentation. I have one suggestion regarding the modeling you could use in your research. I was looking, you have lots of questions. You have a latent variable problem in statistics that is very common in statistics and psychology. For example, in psychology at the 20th century, they tried to measure intelligence. So I was thinking you could use some type of item response theory in order to get lots of questions and try to measure the uncertainty, and at the same time the level of uncertainty of those questions. But just one suggestion in terms of statistics.
Well, so you'll have to elaborate because I'm not familiar with item response theory. So now you'll have to
Okay, no worries.
teach me in the next.
Item
few
response
minutes.
theory, it's a model in which you try to capture one dimension in a series of questions. For
So to
example.
capture the latent variable in
Yeah,
the
yeah.
series. Yeah. Okay.
Yeah, that's the point of my suggestion. I think if you use this type of modeling, you can correlate them and you can try to understand what is common about those measures, why this correlation is happening, and things like that. Just a suggestion.
You're presuming, though, that there is a latent variable, that
Yeah.
there is something in any given legal system that is common to the whole legal system that makes, say, the Brazilian legal system more uncertain than the Canadian legal system. So you could look for, but that may not be true. I guess that's my. I'm not going to presume that there's something underlying all this. Like in the case of IQ, some people think there is a G that is the sort of raw IQ, the raw intelligence that all these different standardized tests are measuring. That's a latent variable there. I don't think everyone is convinced of that. And certainly in this context, I'm not convinced that that's necessarily true.
Yeah, this is an assumption you have to make in order to measure it,
But you see, that's the contextualism. The contextualist in me is not necessarily willing to make that assumption. I might think that administrative law is highly uncertain here, but I can't pick a. Your anti-corruption law is very certain. I don't know. It's the anti-bribery. So, you know, and there's just nothing inherent in the, say, Brazilian legal system that is common to those two areas. So that, to me, is not an assumption. To me, that's a hypothesis to be tested.
Hello, Professor. Thank you for the presentation. My name is Fernando. I'm a statistician on the Brazilian Geometrics Association. And just for the record, we are a research institution that gather data on the legal system and analyze it. So my question is, and please excuse me if I came in a little late, so excuse me if it's redundant, but I would like to know, where does court data fits on the evaluation of legal uncertainty? Because here in Brazil, we observe very different patterns of decision across the judges, even though they judge roughly a random sample of lawsuits. So, thank you.
For me, simple answer. For me, court data is the objective data. I mean, assuming you trust the people who are recording it, but for me, the court data would be the objective data that you might use to explain the subjective levels of uncertainty.
Por favor.
Hi, Professor. My name is Gustavo. I'm a student here. Sorry. I'd like to know, so what is more important to the growth of the uncertainty? Is it the bad decisions by judges, or is it the law being bad written itself? And if the answer to that question varies to according to which uncertainty are we talking about, like disagreement and the ones you talked about. Thank you.
Right. So for me, that's the kind of question that you would be able to answer by using these measures, right? So you could come up with objective measures of the consistency of judges. You could either go into the cases themselves and have some way of determining whether they have similar facts, or you might look at whether the rates at which judges are reversed, some objective measure, let's say. And then you would correlate that. You'd see how that correlates with your measure of subjective uncertainty. You could also try to come up with some objective measure of ambiguity in the statutes, for instance, or reasonably objective measure. Maybe run it through some sort of machine learning program and see what the error rate is, and so, or have a panel of people, ask them to assign the meaning, see if they agree, and so forth. So there are ways of measuring ambiguity in the statutory text, or the level, the amount of discretion they grant, right? So you could code for that, and then again use one of my measures as the dependent variable, right? And figure it out. That's how you'd answer the question. I don't have any answers myself, though. I mean, so what I've been doing recently, sort of playing with this data at the cross-country level, is there are measures of access to regulations. So the World Bank has produced data on that. You know, are the very crude stuff. Is the data, are regulations published? Are they available on the internet and so forth? So you can try to see whether that is associated with unpredictability. You could look at Gini coefficients or something and try to figure out whether that explains the disagreement and so forth. So that's as far as I've only started to walk down that path. Again, this is really the prelude to being able to answer those kinds of questions.
Well, I have two questions, if I may. Kevin, how would you respond to a radical criticism according to which this type of research at the end of the day is based on assumptions such as rationality, and somehow assumes that people behave similarly in different countries, and also assumes that the types of uncertainty that you work with are homogeneous in terms of meaning to everyone. How would you respond to a radical contextualist critic that would consider that this type of exercise at the end of the day assumes a type of behavior that it's not necessarily observable in different societies, in different cultures? And how would you respond to someone who would get to the point to say that this type of research, interesting as it may be, ultimately works and adopts the type of assumptions that the economists have been always adopting, and at the end of the day, someone who would say that this does not bring actual legal content to the type of questions and you're asking and the type of answers you're bringing. I don't believe that this is the case, but I wanted to know to what extent you, as a contextualist scholar in law and development, would respond to this type of provocation, to this type of criticism that could come from someone who's also a contextualist or a radical culturalist person.
Can I take your?
Yeah.
Is that one question?
That's
So-
one question.
Okay, because I heard two questions in there, so
Okay.
and then that I'd like to take, well, three actually. And actually, I might ask you to repeat or restate one of them. Okay, I think the easiest one to answer is the claim that it's based on a theory of behavior that may not be universally valid. I think that's part of what you're getting at. And because that's easiest for me to respond to, because I don't think that these measures necessarily presume any particular theory of behavior. In fact, they can be used to test them, right? So, like if you have an assumption that people are risk averse, or even that a certain proportion of the population are risk averse or not. You can test that with these kinds of data, right? So you can figure out how people behave in response to uncertainty using these data and test claims that they behave the same way in different countries, right? Or in different places, in different societies at different times. So, but I think the more fundamental point is I don't think there's a theory of behavior implicit in the measures themselves, right? Only in some of the theories that you might want to test with them. So that's one point. I think I'm on fairly solid ground on that front. About the conception of rationality, though, that's a little more, that's more interesting, because I think the question about, well, what if, I'm presuming, especially when I'm saying that you can elicit these beliefs using surveys and so forth, I'm assuming that there's a certain relationship between, say, the survey instrument and the beliefs. And so, like, and that may not be valid. It may be the case that people actually think about things for a while, or they deliberate. So let's say that the rationality is a collective rationality as opposed to an individualistic one, right? This whole way of analyzing it, I think there is something to that critique. It is presuming a certain form of rationality. I hadn't thought about it in those terms, but I think that would be a valid complaint. Okay, so those were two of the questions I heard. The third is the one I didn't fully so the first I think I understood and can reject. The second I think is interesting and I have to think about, and that would help me sort of delimit the bounds of the analysis. So yeah, I think that's right. The third thing you said was something about being questioned on whether there is legal content in this analysis. That I don't understand, because I think it is clearly about law, right? But if the question is, well, why are you focusing on the law in people's heads instead of the law in the books, then I'm just saying, well, I'm interested in one thing, not the other. But otherwise, I'm not sure I would understand that particular challenge.
Can I very quickly? What I had in mind when I asked that was, when you started your talk today, you said that these type of indicators are usually produced by economists that are not necessarily knowledgeable about law. And what I understood from that is that what you have here is something that has been done by a lawyer, as you are, and this would imply that you would be willing to bring and inject some specific content, and that's what I call legal content, because you would be proposing something, a type of statistics or a type of probability work done by someone who's familiar with the type of legal problems involved in this case. So my question was, to what extent this method you're adopting, you're working with, effectively takes into account law in its complexity and in its indeterminacy. To what extent, just to be radical, just to make my point clear, to what extent this is not another way to work with statistics and probability as economists usually do? What's new in terms of content, also in terms of method, but how does it? How would you explain the assumption that you made that this is different from what economists and statisticians usually do? And again, just to move back to something that I said before, to what extent wouldn't you agree, or would you reject the criticism that the type of rationality you're working with is the type of capitalist rationality that Max Weber himself had in his mind when he was talking about predictability and as a an explanation for the rise of capitalism in England. Again, I'm just asking questions because not because I necessarily agree with this criticism, but because I think that you must have heard criticisms like this from people who think that this type of work is too it is contradictory with the type of law and development research that people should be doing in terms of recognizing specificities in local culture and etc.
You shouldn't necessarily presume I've heard it before. No, that's part of the value of presenting in different places. So I haven't actually heard that particular criticism of this paper before. I've done other work that has been criticized that way. Actually, the last time was right here in Sao Paulo, not here, but at FGV. Yeah, that one, I think it might be on YouTube somewhere. It was 20 minutes complaining about, I think, the fact that there might have been a little too much capitalism in what I was saying. Anyway, I don't see it in this paper. So I don't think that it's not even a conception of rationality. It's just it's almost a psychological claim about how beliefs are formed about phenomena like legal systems. So I didn't think of this as a particularly controversial set of assumptions. Certainly not linked to any theory of behavior, much less a theory of what sort of law there should be or what sort of social or economic outcomes we care about. None of that. This is way prior to any of that. But as I said before, that doesn't mean that the psychological assumptions are incontrovertible. I do think there is something to the idea, which I hadn't really thought through, that they're still assumptions and potentially falsifiable in important ways. So okay, so that's the more ideological part of it, I guess. But in terms of the professional side, how different is this from what economists do? And is it necessarily different from what an economist could have proposed? No. I would think, some economists have said occasionally that they're interested in legal uncertainty, and I didn't mention in the presentation a very important example of a collaboration between a set of economists and a lawyer, or a set of lawyers in France to try to create an index of legal certainty. What I found instructive there was that it really did not capture the insights that not only a lawyer would have, because it did incorporate the views of lawyers, but a lawyer who looks at multiple jurisdictions, because that exercise is actually a very French measure. So their measure of uncertainty looks at things like, well, whether they presented experts actually with hypotheticals and asked them, well, is the result governed by a written law, or would there be a jury deciding it? And those are all very salient in the French context, right? They presume that having a code and not having juries and so on, those are necessarily good in terms of promoting legal certainty. But those were, very contestable assumptions, or very parochial assumptions. So that even when lawyers are involved, I think it's important to incorporate insights from multiple legal systems and not have assumptions about the particular institutional factors or institutional features of a system, objective features, that will tend to lead to certain sets of beliefs. So no, I'm not making a strong claim that this is the kind of thing that no economist could ever have come up with. Not at all. Or that it's inherent in their methodology and approach that they will that they'll have this have a blind spot towards these issues. No, it's a softer claim to saying they haven't done it before. And I find that often, though. I will go so far as to say that this is not uncommon amongst economists, as far as I can tell, to oversimplify the legal system, to think, well, there's got to be a rule, right? It's just, if the outcome, the law tells us what will happen in a certain circumstance. I may have to ask a lawyer to find it, but once you ask the lawyer, the answer will be there. They do overlook the indeterminacy, and sometimes they underestimate the complexity. Because the smarter ones say, well, I can look up the law, right? and I know what it is, but they don't recognize the problems that arise when you've got multiple sources. I mean, most of what we do in law school is not learn how to read a single statute. If it were that easy, you really wouldn't need to go to law school. It's the problem comes from the interaction between multiple sources that change, and so I find economists tend to be insensitive to the indeterminacy and the complexity. But I don't think that's a necessary feature of their approach.
Thank you. Some other questions? Again, Henrique.
So I have another question, but this one's a little complicated, and I'm still trying to figure it out really. So I'm sorry if it's a little weird, but I like to link this discussion with works about law and development, and ask if you could somehow fit in this description or method you're using non-legal certainty. And I'm thinking about this because I was reading on in the past few months I've read a little about how law and development worked in East Asia, and especially Japan. And what I read described it as very different from how it usually goes in the West. Instead of a lot of legal, economic regulation, law is used to divide the functions and roles of the bureaucracy, and certainty comes not from the rules themselves about what companies should do, or from judicialization. That doesn't happen that much there, but it usually came from the relationships between bureaucracy and the big companies, the zaibatsu. So they were not operating in an uncertain environment, but it was not exactly legal certainty in the way you usually think that it's formal legal certainty. It's a different kind of certainty, maybe. And I know maybe your paper is not exactly about this, but if we're thinking about law and development and how development has worked in East Asia, which is a huge success story, maybe it could be something that's relevant to think about as well.
Right. So the Weberian claim that legal certainty is necessary to the emergence of capitalism is also contestable, right? So a lot of the literature on Asian development and the Asian tigers and so on is framed as a challenge to that claim, and not only a challenge to the claim that you need legal certainty, but as a challenge to the claim that law generally was essential, right? So it's always possible that none of the characteristics of a legal system are really necessarily relevant to a country's or society's or region's development prospects, right? Law may be irrelevant. That's in what in other work I've called one of the skeptical positions that you could take, right? This kind of measure can take us some distance towards testing that claim, maybe. I mean, but even then it's somewhat removed, because if I could figure out a way to measure legal uncertainty at the level of the entire society, right? Then you could take that and sort of test a stylized version of Weber's claim, right? That legal certainty is important to capitalist development. And you could look at Japan and see, did it have legal uncertainty through some mechanism, in some way that we're not observing right away. And you could do your cross-country analysis and so forth, or you could do it as a case study and whatever. So that would maybe falsify Weber's claim or something. But even then, you could say, well, you still have to ask, well, did they have other legal mechanisms and so forth that were conducive to development? If you wanted to, you'd have to go that step if you wanted to test the skeptical claim, or maybe the reverse, test the optimistic claim that law matters. Right? I don't even know if I've helped us with that initial step because, as I was saying before, I don't think I know how to measure uncertainty at the level of the entire legal system. Right? So maybe in a few critical sectors I could imagine doing that, but it's not even there. So this isn't going to be, this only is a very small part, or sheds light on a very small part of that bigger debate about whether law matters, and if it does matter, which characteristics of the legal system matter. But if you, I'll put in a plug. If you're interested, there's the paper I was referring to is called Optimists versus Skeptics and so on, and I think it's available in Portuguese as well. So,
I think we have time for one more or two maybe questions, if any. No? Okay. Okay. Kevin, this was really terrific. It was really great to have you here. Thank you very much. We appreciate that opportunity. We enjoyed the paper and your patience and kindness. Please.
and just one other thing. Half the questions I hadn't heard before. So just to be clear about why I enjoy being able to...
Half of them, you said?
Yeah.
What? Can I ask you something? What was the most...
based on the very...
just by curiosity, what was the most devastating criticism that you had in this paper so far? What was the thing that someone said to you that has caused more doubt or...
today or in general?
In general.
In general, it's prior to today, it would have been about the ambiguity, the limitations of the surveys themselves, right? The questions aren't that precise, and as I said before, they're open to interpretation. So they're is it your neighborhood or your neighborhood or your neighbor? The particular questions I use as examples. So that's, I think that's a problem because even though you could always refine the questions, at the end of the day, there's always going to be some factual uncertainty that's independent of or that's separate from the legal uncertainty, that's conceptually distinct from legal uncertainty. And it's irreducible. You can't eliminate it when you go out and try to measure legal uncertainty. So it will always be inducing at least some measurement error, right? The factual uncertainty that you're introducing in your whatever method you're using to elicit the data. So that's one thing that troubles me. It doesn't keep me awake at night, but I see it as a limitation of the analysis. The other, I'm okay with the ignorance point. Not ignorance, but unawareness is the term that some economists are using for the I have no idea point. But that's an interesting area for future exploration. I can sleep at night with that, but it's that's pretty...
Because it's rather methodological criticism based on the sources that you've used, right? It's not a criticism toward...
No, it's the opposite. The sources actually collect the data on unawareness. They have that I don't know option. I don't know what to make of it as a theoretical matter. That's that's a bigger deal. But I'm in good company there because the economists the people who think about this all the time are really struggling with that. And this series of questions around that you sort of crystallized in the rationality and who you should ask and so forth. Those are practical problems about who you should ask and how you should ask them, the questions. But the idea that there can be deliberation and so on, that I need to think about. Yeah.
Has someone challenged the labels that you use to claim that uncertainty can vary in terms of unpredictability, ignorance, so on and so forth? Has someone said what is the difference between unpredictability and ignorance? For instance, if I replace one by another, that wouldn't make any difference because this can be subjective too, right?
No, that goes. I mean, the particular labels, people might use different labels, but that part of the paper tends to go over quite well. Because the distinction between risk and ambiguity is well recognized, and when I often present this to people in law and economics, and they're very familiar with the model that I was referring to before, the Priest-Klein model of settlement. And as soon as I say that, Priest-Klein says uncertainty, but they're not talking about uncertainty in the case of risk, and they're like, oh, okay, so that part works. I think that works.
And just one last curiosity, from those who work with theory and legal theory and jurisprudence and legal philosophy, have you heard something about this being simplistic or based on the type of assumption that don't necessarily hold when you, I don't know, did you have this kind of feedback?
You know, main concern from that perspective seems to be about the focus on subjective rather than objective uncertainty. They're sort of because if you're an instrumentalist, then it makes sense to focus on what's going on in people's heads. But for some legal theorists, they can't get beyond the idea that law is what's on the books, or it's not, or it's something objective, not necessarily on the books, but it's an objective as opposed to what's in people's heads. But so that's been a consistent source of opposition.
From a critical lawyer, from a critical
no,
legal
it's not
scholar,
from critical. It's
no,
more,
that's
I
not
would say, traditionalist.
No, I agree. That's what I'm saying. But didn't have any feedback from critical people who would say, I agree that law is what on people's mind, but even in that case, I would say I wouldn't agree with this type of approach, things like this, because this is too something. No.
Not so much not in the U.S. because no, and elsewhere, no, not really. No.
Some legal theorists would say, for instance, that law is intrinsically indeterminate. So what's the point of trying to measure or find some determinacy or find some predictability in something that is inherently indeterminate, and this is how law works? I don't know. I of course, that if you work with a car crash accident, that would work somehow because you can estimate X or Y. But when you talk about real complex cases, constitutional fundamental law cases, this would be very limited because it's much more complex. I don't know. I'm just guessing.
No, I think that's the kind of reaction that legal academic will have sometimes, because academics like to focus on the marginal cases or the complex cases, there's a lot of the workings of an everyday legal system that are, more predictable, simpler, and so so I would push back, I guess, against that and say no, that so maybe for all those complex cases the answers are I don't know, right? Okay, that's fine, but that's not necessarily the most important component of a legal system. Those might be the more marginal. Yeah, there's a lot of the legal system that we care about that I think is susceptible to being measured in these ways, usefully in these ways.
That's really true. Yeah. Okay. Thank you.
Thank you.
Okay, so once again, thank you so much, Kevin. This was really wonderful. It was a great opportunity for us. We appreciate indeed. Muito obrigado a todas e todos que estiveram aqui. Por favor, fiquem atentas e atentos para os próximos eventos do nosso grupo. Quero agradecer em especial, mais uma vez e sempre, ao Henrique e à Beatriz, que trabalharam comigo na organização desse evento. Obrigado. Sem vocês sabem bem disso, as coisas não teriam acontecido. Muito obrigado a todas e a todos. Um bom dia. Thank you so much, Kevin.
Muito obrigado.